tax on the building. And this was the subject of a very important book in the 1950s, which nobody reads anymore, by Vidal in French, La théorie de la fraude à la loi, the theory of fraude legis, and his conclusion was it does not apply to tax law. Well, in the meantime, the principle of abuse of law started being applied in tax law. It started in Germany in 1919. Germany was in a difficult situation, and they introduced in the Reichssteuergesetz a provision saying, well, if you abuse tax forms in order to artificially put yourself into a better tax position, the tax administration will not consider that it is lawful. Then from Germany, it spread to France in a legal provision which was introduced, strangely enough, in 1941, and which said it was very obscure because, of course, simulation has always been considered as not acceptable by the tax administration as by anybody. If you simulate an act under the disguise of another action, well, your creditors, etc., may disregard that. And the French provision seemed to apply to simulation and to abuse of tax law. It was on the books, and it went with heavy penalties. In the meantime, in the United Kingdom and in the United States, they developed the theory of business reality, business purpose, or in England, of the step transaction. If through various transactions you put yourself in a position which is artificial and which has no business purpose, this will not be recognized by the courts. And we were faced with those two legal systems, and several countries started thinking about introducing general anti-abuse clauses in their legal system. The so-called GAR, General Anti-Abuse Rule. We know that in tax law, we have several specific anti-abuse clauses, the so-called Sars. For instance, if you artificially buy a loss company to use the losses of that company against future profits of a business which you put in the company, well, in almost all legal systems, there is a SAR which will make that ineffective. And so several countries started introducing GARs on top of SARs. And there were two congresses of the International Fiscal Association where the general reporters noticed that it was spreading, that the anti-abuse clauses were spreading all over the world, and that it made, of course, tax planning very difficult because you cannot give anymore a clean opinion in domestic law saying, well, if you do that type of merger, for instance, between a loss company and a profitable company, will it be accepted by the tax administration, or do you have to show that you have a real business purpose? And what is a real business purpose? We all know that this is difficult to give evidence on that. Then the question arose, can you apply that anti-abuse rule to a treaty situation? In other words, can you abuse a treaty? you want to do business in the United States, your country does not have a treaty with the United States, well, you create a company in a country which has a treaty with the United States. Is that the abuse of a treaty? First, you know that the OECD developed a model tax treaty many, many years ago. Well, the commentary of that model tax treaty is an excellent source of tax doctrine. And that commentary said, well, no, if the treaty provides for an anti-abuse clause, it's all right. Otherwise, the treaty must be applied. And then suddenly the OECD changed its viewpoint completely. And in a further version of the commentary said, no, the anti-abuse clause of national law is part of the facts to which the treaty applies. And so if the situation is abusive, well, the treaty will not apply. Many commentators, among the best ones, disagreed with that view. But it was in the commentary. And then, in a parallel way, European law began to develop in that field, and it started with VAT. You know that it's important to get a VAT deduction. And in an English case, Halifax, a bank in the UK developed a very complicated scheme in order to avail itself of deductions, whereas normally in the banking business, you are not subject to VAT and you don't enjoy the deductions, the VAT deductions, for instance, if you build a building, and that was the case. And then for the first time, the European Court of Justice decided that there was a general principle of European law prohibiting abuse of law. We don't have necessarily that general principle of law in our legal systems, but we have it in European law, stated the court, and so in every situation which is inspired by European law, for instance, VAT, you have to apply it. And then there was a second case, very important case, Cadbury Schweppes, about an English company having created subsidiaries in Ireland with a very favorable tax system, the Irish tax system. And there the court said, well, if those companies have substance, you may not say that it is an abuse. You may say that it is an abuse of law only if the situation is totally artificial. And then there was an additional principle that you may not have a general rule in a legal system giving you a presumption of abuse of law. For instance, in the French law, there was a presumption that the parent subsidiary directive, which, as you know, provides for an exemption of withholding taxes on dividends between a subsidiary and a parent, that this would not apply if you interpose a European company between a third country company which does not enjoy the benefit of European law, of the directives, and a French company. And in two cases, one about France, one about Germany, the European Court of Justice said, no such a general presumption. You have to give evidence that there is an abuse of law. There we stood. And then came BEPS, base erosion, profit shifting, actions of the OECD at the request of the G20. At the same time, money laundering, etc. But here we accounted in the tax law. And in the BEPS report on action number 6, the actions of BEPS are numbered. The OECD said, well, treaty abuse should be prohibited. Treaty abuse should be prohibited. And that was, of course, a report. But then the European Union thought it is impossible that this would be implemented in a different way in the 28, at that time, 27 now countries of the European Union. So they took a directive, the Anti-Tax Evasion Directive in 2016, the so-called ATAD, Anti-Tax Avoidance Directive, stating, among other things in Article 6, that for corporate law, corporate tax law, you had to disregard any arrangements which were entered into with the purpose of avoiding the application of a tax provision if it is contrary not to the tax provision, but to the purpose, to the objective of the tax provision. So this is really the doctrine of abuse of law, or false legis. You avoid the application of a law by acting contrarily to the purpose of the law and not to the text of the law. You see how difficult this is to apply. And so this is the ATAD directive. And then BEPS provided in Action 15 for the signature of a multilateral agreement which would apply to several bilateral treaties which the countries would agree to submit to the multilateral agreement. And in that multilateral agreement, there is a provision, first, that all treaties, tax treaties, should have a preamble stating that they are not entered into for the purpose of creating double non-taxation, or what we call treaty shopping. And second, that any abuse as defined, any action against the purpose of a tax provision will be disregarded by the tax administration for the application of the treaty. And Romania and many countries signed that multilateral agreement, which is so applying to various bilateral treaties. There we stood. And the model treaty of the OECD was also amended in the same direction by its Article 29. So I will say it makes our life difficult, but it was not enough. Our life is had still to become more difficult, because Action 12 of BEPS said, well, you have to disclose to the tax administration aggressive tax planning. What is aggressive tax planning? Well, and a new directive under the Exchange of Information Directive, and it is called DAC 6, Directive on Exchange of Information number 6, obliges you, my lawyer friends, when you devise a scheme which may be perfectly lawful, but which corresponds to certain characteristics, certain markers, which are enumerated in the annex to that directive, which compels you to disclose them to the tax administration. And then you will say, well, what about my professional secrecy, my duty of confidentiality? Okay, it's good. If you consider that you're a lawyer and accountant, you have a duty of confidentiality, a legal privilege, you may apply it, but then your client has to disclose himself. And if he doesn't, well, then you have to take the necessary steps. So several lawsuits were introduced before the constitutional courts, for instance, in France or in Belgium, saying it is contrary to the principle of professional privilege, which is the basis of the law. And the governments answered with a reasoning which comes from the money laundering directive, saying, no, no, a lawyer is protected by the privilege only when he assesses the legal situation of a client or when he defends a client in court, but not when he develops a scheme. It is the essence, of course, of the advice of a lawyer to give advice and to develop the schemes. If you advise on a merger, even on a sale of goods, you're developing a scheme. So that makes our life still more difficult, but it's not enough. Let us have a brief look at the future to conclude. There is now a draft directive on shell companies. It is called the Unshell program. If you have a shell company, which means a company which has no other purpose than to invest in other companies and which has no activity, you must report that to your tax administration, which will exchange the information with the other European countries, member states of the European Union. So does it mean that it will now become impossible really to create a holding company, or that you have to give a lot of substance to a holding company, which very often is useless because a holding company does not require really much office space or much employees in many situations? That will be for the future to say. And what I wanted to tell you is that maybe we are going in Europe and in the international field and in the domestic field, for instance, in the Romanian tax code with the Romanian anti-abuse provision, we are going maybe one bridge too far. So let us stay on the road and let us see whether we shall cross the bridge. Thank you.
Thank you, Professor Malherbe. Clearly an interesting presentation, which may actually raise questions, or at least may actually open doors to other debates. So let's see if anyone online or here in the room has any questions to address. If not, I would actually have a question addressed generally anyway in relation to the single market and how actually you professors see the evolution of tax in European Union. Clearly we know that VAT is there and also represents source of the EU budget, but in the latest time it's a debate on how some states, important states, want actually to introduce more elements in the treaty, or at least to come with a more harmonized view on the tax law, which still remains a national attribute. How do you see this also in relation to the theme that you presented today?
Yeah, it's a very interesting question. I think it will be solved indirectly by the OECD in what they call Pillar 1 and Pillar 2. Because the European Union, Pillar 1 wants to move tax substance to the countries of the market where products are marketed, and Pillar 2 wants to introduce a minimum tax rate of 15%. And the European Union plans to implement that, at least Pillar 1, through a directive. And that directive will necessarily have to harmonize some elements of the tax law in Europe. But it will apply only to companies having a turnover of more than 750 million euro. So we shall have, in fact, two tax systems, one for very large companies and one for regular companies. What I think is that this will be very difficult, and that the tax law for corporations, at least in Europe, will have to be harmonized to a larger extent. First, we shall see that harmonization for very large companies, but then I think that the time will come when, to a large extent, the tax law will be harmonized, the business tax law for corporations. For individuals, I don't think that it will be possible because the differences between our individual tax systems and the political implications are too important. So let us wait and see what happens with Pillar 1 and Pillar 2 of the OECD.
Thank you very much. So we go from, anyway, internationally go at European level, and still we keep it at least from one point of view very national. And because you mentioned individuals, yes, we speak about many actors over there, and we have to differentiate between the taxation of individuals and even their activities, and the corporate tax, which clearly is more connected to the single market. Thank you very much, Professor. Thank you for all your involvement with the faculty's projects, and for being here today and presenting such an interesting theme. Thank you very much. And because we said individuals and we said anyway single market, I think we can actually switch from tax to consumer to actually the consumer's rights. And the next speaker is lecturer PhD Juanita Gojikovic, who comes with a paper on collecting consumers' consent to collective redress actions under EU consumer law, opting in or versus opting out consent and hybrid consenting mechanism. She's an attorney at law and a lecturer, so both academic and practitioner. Thank you for coming here today, even online, and we hope to have some questions after the presentation. Mrs. Gojikovic?
So collective redress mechanisms in business to consumer litigation continue to raise significant interrogations for legal practitioners. That's becoming more stringent in the context of the recent entering into force of Directive 2020/1828 on representative actions for the protection of the collective interest of consumers, which requires EU member states to organize a system of representation aimed to protecting the collective interest of consumers against affectionate infringement of EU regulations applicable to business to consumer contracts, including cessation orders and remedial measures. So our study attempts to explore the applicability of the main provisions of Directive 2020/1828, which empowers qualified entities designated as such by the member states to bring actions for obtaining a cessation order or actions for obtaining a repair order, including compensation or replacement on behalf of a group of consumers who have been harmed by a trader about whom it is alleged to have infringed one of the EU legal acts, while setting specific eligibility criteria for qualified entities. The directive distinguishes between qualified entities that have the right to bring actions in the member state in which they have been designated in internal representation actions, and the qualified entities that have the right to bring actions in any other member state in a cross-border representation action. And for domestic actions, a qualified entity will have to meet the criteria set out in the law designated by member states, while for cross-border actions, it will have to meet the harmonized criteria set out in the directive. So as a measure to protect against abusive litigation, the directive provides clear rules on the allocation of legal costs in a representation action for redress based on the loser pays principle. So the litigating party who has lost the action will be required to bear the procedural expenses and procedural costs, while additionally, in an attempt to avoid implicating interest or potential conflict of interest or even collision of interests, it imposes a set of transparency requirements on qualified entities, so in particular as regard their financing by third parties. So representative actions pleading for the respect of collective consumer rights may seek injunctive measures or under certain procedural circumstances, redress measures. So as for the first, injunctive measures are described as measures aiming to protect the collective interest of consumers, irrespective of whether any actual loss or patrimonial damage is suffered by individual consumers, and irrespective of whether the unfair commercial practice consisted in intentionally committed actions or contrarily was the result of professionals' inexcusable negligence. So obviously, such measures can require practice to be ceased, or on the other version, can require traders to make or to take specific actions, such as providing consumers with information that was previously missing or has been culpably omitted. Redress measures, in contrast, are defined by scholars as measures requiring a trader to provide consumers actually affected by an infringement of relevant mandatory provisions of EU law with particularly concrete remedies such as compensation, repair, replacement, a price reduction, or contract termination or price reimbursement as appropriate and available under EU consumer law or under national mandatory legal provisions. So in terms of opting out and opting in consent of consumers, a twofold approach is to be noticed. In terms of this type of duality in opting in consent of consumers versus consumers opt-out consent. In accordance with the provisions of Article 8, the third paragraph, for instance, in Directive 2020-1828, in the perimeter of collective actions pursuing injunctive measures, individual consumers will not be required to express their wish to be represented by that qualified entity. A tacit consent thus being presumed, while allowing the consumers to specifically and expressly opt out from a collective representative action pursuing injunctive measures. Should individuals refuse to be represented by the qualified entity when seeking an injunctive measure against professional traders concurrently, in this particular hypothesis, the qualified entity will not be required to prove the occurrence of actual loss or damage on the part of the individual consumers affected by the infringement as referred to in the second article, the first paragraph of Directive 2020-1828. Nor are these qualified entities compelled to prove the culpable intent or unjustifiable negligence on the part of the trader. So due to the objective premises, independent of the proven culpable behavior of the legal ground of the action seeking the covering of the consumer's economical or patrimonial loss. So on the other version, a specific and granular opting in consent is required from represented consumers for the using of a collective redress mechanism based on the provisions of Article 9 of Directive 2020-1828, requiring the professional trader to provide consumers concerned with remedies such as compensation or repair or even replacement of price reduction, contract termination, or reimbursement of the price As to the substantial and formal requirements for the validity of the declaration of consent, national legislators would have the competency of laying down rules on how and at what stage of a representative action for redress measures the individual consumers concerned by that representative action explicitly or tacitly express their wish within an appropriate time limit after the representative action has been brought to be represented or not by the qualified entity in that representative action, and to be bound or not to be bound by the outcome of the representative action. So, in my opinion, in order to be able to respect their legal traditions, national legislators have to preserve the choice between an opt-in mechanism and opt-out mechanism, or a combination of the two for redress measures or hybrid procedures, also being possible when deciding at which stage of the proceedings consumers should exercise this right. And several dichotomies and implicating aspects are worth noticing, in my opinion, since under an opt-in mechanism, consumers are required to make an express will or to manifest an explicit intent to be represented by the qualified entity in the representative action, aiming at the obtaining of these redressing measures. While on the contrary, its opposite, the opting out mechanism, implies that consumers are required to express their will of not being represented by the qualified entity in a collective litigating procedures. So as previously remarked, Directive 2020-28 provides for safeguards against the abusive litigation, which is historically associated with class actions in other jurisdictions, both in terms of not allowing judicial courts to impose punitive damages on the infringing trader. Although these remedies remain available under common procedures when regarding the professional trader's liability for lack of contractual conformity, for instance, and in terms of opting for the litigating party who lost pays the procedural cost principle, which ensures that the unsuccessful party pays the procedural costs to the successful party. And this principle remains applicable independently of the quality of consumer as a plaintiff or, on the other person, as a defendant. So congruently, as a conclusion, EU member states are expected to ensure that the court or the administrative authority in front of which a representative action has been brought can dismiss manifestly unfounded cases as soon as it has received the fundamental information grounds to justify the rejected decision. So finally, a further safeguard against abuse of litigation is the eligibility for specific entities to represent groups of consumers harmed by relevant infringements of EU law, which for obvious reasons is limited to the mentioned qualified entities, such as consumer organizations and public administrative bodies. Thank you so much for your attention.
Thank you so much for your presentation. I was just wondering, did you hear about any cases that might have caught your attention regarding the consumer's protection recently?
Not in our national jurisdiction, obviously. Perhaps in other member states. Yet in our jurisdiction, they are still using common procedures when retaining the professional trader's liability for lack of contractual conformity or lack of product security. So at the national level, there are no special procedures yet implemented in this field of collective redress.
Thank you very much. Next, we have lawyer and PhD candidate Isabela Porcius with her paper and presentation, E-commerce in Europe, Current Status and Cybersecurity Recommendations. if you can hear us.
Yes, I can hear
Thank
you.
you.
Good afternoon, and thank you very much for this honor and great opportunity to participate in the conference, and also for allowing me to present earlier due to some program issues. Just to open my presentation. Okay. So, as you have already anticipated, my presentation concerns e-commerce in Europe, current status, and cybersecurity recommendations. E-commerce and also cybersecurity represent my main preoccupation during my PhD studies, and therefore I have also chosen to present you some aspects today. First of all, I will talk briefly about the evolution of e-commerce in recent years at European level, just to have idea about the current status. Last year, ECommerce Europe has issued a report regarding the 27 member states of the European Union and also 10 other digital economies on topics regarding e-commerce and trends and its evolution. The conclusions of this report show that due to the COVID-19 pandemic, the affirmation process of e-commerce has accelerated. So in these terms, the report noticed that it has been a significant increase in the number of customers who wanted to be involved in e-commerce, and at the same time to be safe from the pandemic. At the same time, the report showed that the share of the gross domestic product represented by e-commerce has also increased. And I have also some numbers in this regard. So in 2017, the eGDPT was at 3.11%. Then in 2019, there was 3.93%. And in 2020, we already see an important increase to 4.29%, followed by 4.60% in 2021. At the same time, all of the countries analyzed in this report have experienced increase in business to consumer e-commerce turnover. Another study, more precisely a survey conducted by Eurostat, the statistical office of the European Union, has showed that online purchases by internet users increased by 20% from 2011. Oh, I'm sorry. So, no. Just a second. Okay. Okay, so how I've already mentioned, the online purchases by internet users increased by 20% from 2011 to 2021. So in a decade, there was an increase by 20%. And this increase is typically observed in age categories from 25 years to 54 years, and also in the age group 16 years to 24 years old. So the largest share of online shoppers was among those between 25 years old and 54 years old. But at the same time, starting with 2019 and 2021, the age group 16 to 24 took the lead. So it's not a surprise due to the fact that this age group is more likely to use technology and also e-commerce. But it is important to notice that all of the age categories, including the age group 55 to 74, who had an increase by 15% also in the last decade. At the same time, the Eurostat has noticed that e-commerce activity is influenced by the background of the person. And here they talked about age, education, and also employment status. So men are highly more interested in e-commerce than women, and also a highly educated person are more likely to conduct e-commerce activities than people who have a lower educational preparation. And also, it is common sense that unemployed people and retired persons have a lower interest in e-commerce due to their financial status. The main issue that has to be taken into consideration when it comes to e-commerce is not just to gain profit from e-commerce from the point of view of business, and or to shop online, to engage in e-commerce activities more comfortable and relaxed from the point of view of the consumers. The main priority should be to avoid to have more disadvantages when making the transition from the ordinary commerce to e-commerce. And here I'm talking about implementing cybersecurity measures and taking the appropriate measures to avoid cybersecurity incidents that are very common in cyberspace. So when we make the transition from the physical world to the digital world, it is important to have in mind that cyberspace should not be taken for granted. It has to there has to be cybersecurity behavior and in attitude towards cybersecurity from the consumers, and also there has to be well-established cybersecurity policies and cybersecurity measures implemented from the side of the businesses. And in this regard, I will talk briefly about main cybersecurity recommendations, and I can say also basic cybersecurity recommendations issued in 2020, so in March 2020, when the COVID-19 pandemic was at the top, and most of the European states have declared the emergency status. The European Union Agency for Cybersecurity issued some, as I have already said, some basic cybersecurity recommendations. Regarding the side of the customers, it is important for them to update their systems. And here I'm talking about operating system, apps, and also antiviruses. So customers, so every person should have in mind the entire computing system that they are using. So not just some elements, so not just to update the antivirus and not update other software or apps, because cybersecurity incidents may appear everywhere, especially when there it is a vulnerability, a technical vulnerability. Moreover, customers should have in mind the importance of privacy. And here, unfortunately, I have noticed that people usually take for granted the topic of privacy, because they usually say that it cannot happen to me, or I'm not as important as others for cyber criminals. And this is a very destructive, I may say, a very damaging attitude towards privacy. In this regard, regarding privacy, customers should have in mind to use strong passwords when they create accounts on platforms of e-commerce providers, especially when they also provide information about their credit cards. Moreover, they have to pay attention to use secure communication channels when providing information about themselves, especially when it is when there are sensitive data. At the same time, it is important for e-commerce customers to observe, to pay attention to cybercrime indicators. And here I'm talking about, for example, security protocols, which can be found in the address bar of e-commerce websites. At the same time, it is important to pay attention to emails, to verify the identity of the sender, and also the authenticity of the solicitation that it is included in the email, and also to not open attachments that do not provide security warranties. Another important aspect to have in mind for customers is payment fraud. And here it is important for them to notify to the banks whenever they notice or they have some issues regarding their bank accounts, credit cards, due to the fact that people usually give away their credit card information without having in mind payment fraud implications. And from the point of view of small and medium enterprises, which are the most common actors who perform e-commerce activities, the European Agency on Cybersecurity has recommended them to build a strong website security. And here it is the issue of multi-factor authentication. So, and also to store securely the passwords of the clients. and also to regularly make security tests. At the same time, the SMEs have to build a well-established security policy, and here they should have in mind all of the elements of their business and all of their software and hardware. So all of these have to be secured, properly secured, and they also have to organize their cyber incident response mechanisms. So it is not just about taking the proper security measures to prevent cybersecurity incidents. It is also about being able to properly respond to these incidents when they occur, because there is not such a thing of the perfect cybersecurity. So due to the fact that cyber incidents are continuously evolving. So the security policy of a proper security policy should contain both technical measures, but at the same time, organizational measures. Another important issue to be tackled by SMEs is data protection. And here it is very important for them to respect and to comply with the legislation in this field. And here I'm talking obviously about the GDPR. And at the same time, it is very important to notice that the data protection authorities in the European Union, also in Romania, have in the last year have issued many sanctions regarding breaches of data protection. And with this regard, it is important for SMEs to comply with all of the regulation and to avoid being sanctioned by the data protection authorities. So as the conclusion is that when it comes to e-commerce, and not just to e-commerce, to all of the activities which are conducted in cyberspace, cybersecurity should be the main priority, because you cannot benefit from an activity conducted over cyberspace if you lack cybersecurity measures. So regarding cybersecurity in e-commerce, there are not just obligations from the point of view of the enterprises, from the business point of view, but also from the customers, because they are also responsible for their behavior in cyberspace, for their behavior towards cybersecurity and towards its importance. So both the business actors and the customers, so the clients, the consumers, have to acknowledge both their rights in cyberspace, but at the same time their obligation when it comes to the topic of cybersecurity. So thank you for your attention, and again, thank you. I thank the organizers for this great opportunity to be a part in this conference, and I hope that we will see again next year in the next edition of the conference. So have a wonderful day and thank you.
Thank you. We continue now with a colleague from the Department of Law, of Faculty of Law, Professor PhD Silvia Cristea. One of the, next to the ones who were in the opening session, one of the members of the department who work a lot and we consider a founder of this young faculty of law from the Bucharest University of Economic Studies, professor of some of us some years ago, and a mentor for many of us from our department. She will present a paper which is related to the patrimony of individual merchants. The title is Patrimony of Affectation, a limit of the liability of the owner of the individual enterprise.
Thank you. It was a presentation. Very nice. Thank you, Mr. Dean. So, the abstract contains this idea. This study aims to present some introductive considerations, after which we will give special attention to analyze the legal regime of the individual enterprise in comparison with other legal institutions, Section 1, 2, and 3. The original part of the study concerned the analysis of the notarial practice that highlight the procedure of the transfer of a good from the patrimony of affectation to the person patrimony of the lawyer, owner of the office, Section 4, as well as the conclusion that emphasize the interest of amending the Romanian law following the model of foreign laws. A rhetorical answer will be given to the question if the support program for small and medium enterprises can be an additional solution for the owner of the individual enterprise in the context of the economic crisis generated by the COVID-19 pandemic, Section 5. I will follow the third PowerPoint. The owner-entrepreneur of an individual enterprise versus the trade fund. It means Section 1. The trade fund represents the legal universality in fact constituted from the totality of fixed assets, the tangible and intangible assets which a trader uses in exercising its activities. By this formulation, we understand that the trade fund does not have legal personality, except patrimony, which is constituted by the totality of rights and obligations of a law subject, is a legal universality in fact, and cannot be legally protected, unlike the regulation of French law, quoted from Smaranda Angheni. Until the GO 44/2008, the Romanian regulation in the matter of the trade fund is adopted the theory of in French doctrines, according to which the trade funds is a universality in fact, and each element will maintain its own individuality, marks, export authorization, labor agreements, and all tangible fixed assets, being able to transmit separated the trade fund. We consider that after the regulation of GO 44 will bring a new conception. Starting from the theory of patrimonial affectation, we assist in the concentration of assets into a different trade patrimony represented by trade law. of legal protection benefits the debtor trader who can invoke the existence of a civil patrimony named nest egg constituted with the assets which are not used in trade activity, and a different trade patrimony, respectively the trade fund or individual enterprise. This explanation is argued by Art 26 of Geo 44, which institutes the liability of the owner for the individual enterprise with the patrimony of affectation in case this was instituted and with the entire patrimony in addition. The formula chosen by the lawgiver is perfectible. From the interpretation of Art 26, we can conclude that the natural person could be liable for the entire fortune. If that is so, why would choose a person this legal statute when there is already the one of authorized natural person? Going to practice. Aspect of notarial practice that highlight the lack of legal personality of a professional, namely commercial activity, Section 4 of the article. A possible case in practice is that in which, when drawing up the sale-purchase contract, the holder of the property right, as buyer, registered in the land registry is a law office, registration based on the sale-purchase contract concluded, the real estate being encumbered by a mortgage right in favor of the bank that financed the acquisition. The owner of the law firm requested the inclusion in the sale contract and then in the bank loan contract of a clause according to which the building will be the headquarters of the law office. The purpose of this clause is purely fiscal. Respectively, in order to take into account when determining the tax base of the office bank interest and the depreciation expenses, as well as deductible expenses, this possibly being provided by the tax code on the principle of using the property for income generation. The National Union of Public Notaries in Romania, ruled by the minute of the Commission meeting on February 17, 2015, which assessed that in the situation where it was registered in the land registry as the holder of the property right or other real right, an entity without legal personality bears office, law firm, notary office, authorized natural person. The land book situation is to be rectified based on the authentic declaration of the holder of the registration, whose rectification is requested according to Art 1907 et al. In Civil Code. The land book notes the circumstances that the building is affected by the exercise of an authorized profession, according to Art 18 of Order 720/14 of Civil Code. And this I quote from Cuckoo article. The next PowerPoint contains my belief that the above solution can be extended to an individual enterprise. In addition, in this case, we consider it useful that the notary, before authenticating the declaration of the owner of the company, according to which the rectification of the land book is required, request a document providing the cessation of economic activity of the company. For example, in the form of proof of deregistration of activity issued by the trade register in which the enterprise was registered. Taking into account the optional nature of the patrimony of affectation, mutatis mutandis, We consider that the sale of the property is possible in case of continuing the activity of the enterprise, but when the will of the enterprise owner is to alienate the good, not to keep in the patrimony of affectation. We must specify that even in the current Romanian legislation context, the law allows authorized professionals to alienate a patrimony of affectation as legal universality by act between the living. There are express provisions in this regard, and I quote in the paragraph. Why not extending this possibility to the natural person trader, respectively, the authorized natural person and the owner of the individual enterprise? And now I make a comparison between Romanian regulation on the subject. We can compare law number 48, 2017, like an amendment to law 95, 2006, which contains in Article 73 the following provision. The taking over of the activity of an existing praxis by another family doctor in the condition of the cessation of the activity of the titular doctor is done by transmitting the patrimony of professional affectation held to the doctor who takes over the praxis. And the other one, from the statute from the profession of lawyer, according to Art 119.8, professional civil society does not end in the situation of partial division or detachment, such as if part of his professional patrimony of affectation is detached and transferred to another form of practicing the profession of lawyer which exists or which is thus established. As a conclusion that emerged from the analysis of the legal regime of the individual economic enterprise, it also shows the need to revise the regulation applicable to individual carrying out economic activities, given that the provision of the Civil Code do not contain edifying provision on the patrimony of affectation. To this is added the inaccuracy of the formulation contained in the Code on essential institutions, such as the concept of professional, who replaces the legal institution of trader previously regulated by the Commercial Code. Moreover, a model in this respect we can find in the French Commercial Code, modified in 2010. In sole ownership with limited liability, and I quote here Anne Charlotte. Law entered into force starting January the 1st, 2011. According to this law, any individual entrepreneur may affect to his professional activity a patrimony of affectation, separate from his personal patrimony, without establishing a legal person. This patrimony is made up of all the goods, rights, or guarantees belonging to the individual entrepreneur that are necessary for the exercise of his professional activity and which he decided to effect for this purpose. A possible solution to be taken over also contained German legislation, the separation of patrimony called Zweckvermögen in a German Civil Code, which allows a person, natural or legal, to own several patrimonies fully autonomous. We agree with the opinion formulated in the Romanian specialized legal doctrine, such as Tuleashcă, according to which the legal regime of the patrimony of affectation of the natural person trader is the least protection in relation, for example, to the affected patrimony of the authorized professionals or even with the fiduciary patrimony. We also agree with the proposed de lege ferenda of the same author in the sense of generalizing the principle of full autonomy of the patrimony of affectation, both between them. For example, that of the individual trader, that of the authorized professionals, and in the relation to the personal patrimony of the individual trader, in this case, of the owner of the individual enterprise. In this regard, we propose, de lege ferenda, the introduction of the following provision in the text of Governmental Emergency Ordinance GO 44. The taking over of the activity of an existing enterprise by another natural person trader in the condition of the cessation of the activity of the owner is done by transmitting the patrimony of affectation held to the natural person trader who takes over the activity. In this way, the difference between the legal regime of the professional natural person and that of the professional legal person in terms of limiting liability for commercial debts will be diminished. The liability of the natural person trader will no longer be unlimited but limited, respectively, to the extent of the patrimony of affectation. By adopting such an amendment by Romanian law on limited liability matter, the lack of legal personality would no longer be a disadvantage for natural persons, whether it is authorized natural person, individual enterprise, or family enterprises. Thank you very much.
Thank you, Professor Krista. Yeah, it's something that we debate. We also teach, yeah, and Faculty of Law, but also at all the faculties in our faculty, in our university. Now, in relation to European market, the single market, and the right of establishment, how do you see the evolution of these three forms and the legal regime of the business patrimony that you presented today in the future? If you see any adjustment, or the forms are adapted now to the market?
First of all, I have to say that many economics professional does not make the right difference between personality, such as company law, and person, like individual. So this is our task as professor to make them understand even as students. So the difference I see between the rules, I think they are not so distinguished between the third person, the third. I think that in the future, it will only natural person authorize. I think that individual enterprise will disappear, because the difference between the two authorized person and individual person are so not very important from the base of the rules. So I think one of them will disappear. I don't know which one. I suggest that individual enterprise will disappear. Family enterprise will continue because if you don't want to have personal liability and you want to choose to make your commercial activity in your family, relatives, this is the best option. So, this is my opinion. We'll see in the future. Thank you.
Thank you, Professor. If there are no other questions, we are in time, and we can actually invite the next speaker, Professor Patrick Sensburg from Germany. He's a visiting professor at Faculty of Law of the Bucharest University of Economic Studies. And I started with this because I like this. I'm co-teaching with him two subjects at our university. But he's also visiting professor at Vienna University and is a teacher in Germany at Münster University. He's a teacher of European law, public law, and he is also very involved in active activities. He was a member of the German Parliament and also reserved in the German army. We would like to invite him to address with the issues related to single market from his perspective. Thank you, Patrick, for attendance. I don't see exactly, but I think you're online, yeah?
Definitely I am. Okay.
Thank you.
So, if I can start, I will do. And first of all, I would like to thank you very much for the invitation to the conference Perspective of European Business Law. I think it comes in a perfect time. I will describe later on. This conference covers such a wide range of issues considering the European business law and the various influences to it that I can give many, many impulses to Brussels, I think. That's one possibility. So I think what we elaborate today, what we discuss today is not something for the scientific community. Of course it is, but it can also reach the political decision makers because we're talking about an issue that is, of course, important since nearly 70 years, since the founding treaties of the European Union, but it will be more and more important on a global perspective, but of course also on a European perspective. So you choose the right topic, you choose the right time, and I'm very thankful that I can be with you together. And it's also, a big value for the community who are talking about European business law to find a common ground, to develop it, to go further. I think the more and more European integration is of great importance we see in the last years. And so thanks again to the organizers, especially to Ovidiu Dumitru and the whole ASE team, represented in the morning by the rector Nicolae Istudor in the first. So thanks again that I have the chance to be here. Thanks again that I have the chance to listen to the speeches before and the speeches afterwards during the whole day. So the economic crisis over the recent years and the Brexit also render improvements to the stability of the European Union internal market as a key task at present. The Russian war in Ukraine even intensify this need. Also, the law, particularly private law, can make a patent contribution. The business law of the internal market is lagging far behind. Companies and traders conduct their activities in a common market and in 19 EU member states using a common currency. They cannot, however, utilize a common law for this purpose. Companies and traders are instead confronted with a split in the law. On the one hand, the bulk of business law is comprised of a multitude of national laws whose provisions often vary considerably. On the other hand, European legislation only strives to harmonize or unify particular aspects, yet with fragmentation, or I can say incurrency. So this, in front of the backward of the European Green Deal, which will influence us, all of us in all kinds of fields, I guess, and the global changes which shows the Russian aggression will have to the economy of the whole world, the European internal market will become more and more important than ever, as I already pointed out. A strong European market is also a guarantee for strong negotiations also with third parties if it comes, for example, to trade negotiations and to trade agreements. So on one side, it's an issue about the European internal market, of course. So it's an internal issue to strengthen right from the beginning the three treaties and to strengthen our internal market. But it's also a clear position for the European Union to the rest of the world. So it will strengthen also our position in a global market. So I will not present the history of European business law since the three founding treaties of the European communities in the 1950s. And I will also not pick out special problems of European business law. I will not go through the corporate law, banking law, financial market law, electronic commerce, competition law, credit security law, insolvency law, insurance law, intellectual property, social law, tax law, or for example, the Societas Europae, SE, or the Societas Cooperativa Europae, SC. Of course, for example, the two last ones, state status or state, from my point of view, minimal standards of these statuses. I will not mention the corporate law directive, the one-person company directive, the shareholder rights directive, the takeover bids directive, and the harmonization measures in the area of accounting or auditing law. At least, I will not talk about the latest proposals of the EU Commission in the field of European business law. So, what I will do then? I will talk about the need of an European business code. And I think this could give some impulses, as I said in the beginning, to the scientific community, yes, on one side, but also to the lawmaking process on European level in Brussels. Since many years now, there have been various attempts to create a unique European business law. A European business code could ease cross-border economic activities between companies and traders, and also, as such, be a code for European traders and companies. It would especially benefit minimum and small-size enterprises, the SMEs, without branches in other member states and without the financial resources for legal advice concerning a different member states. A European business code would not only be of considerable economic use, but would be of political significance as it would carry European integration into day-to-day business life. So all these efforts, all these benefits could last in the end or be a result of a European business code. So that's why I want to speak today right away out that we need a European business code. So many impulses is to speak, and so many reasons we could talk about that speak for a European business code that should be developed in the next years. And this should get parallel to the development of a new fundamental treaty following the Lisbon Treaty, which is now in power. So the Lisbon Treaty getting into power 2009, as the treaty of a constitution for the European Union didn't work out. So 2009, the Lisbon Treaty came with the mostly needed compromises, and 2009 is already more than 13 years ago, or around 13 years ago. Jurists can calculate, sorry. So around 13 years ago. 13 years is a long period for such a fundamental treaty. So from my perspective, we need a new one. We should elaborate a new one. This takes some time. So we should take our time in the next, let's say, 5-6 years to talk about a new fundamental treaty, following up treaty to the Treaty of Lisbon. And aside to this, I think it's a good time to discuss and to elaborate on the basis that's already there, a European Business Code. When such a project should be successful, content, methods, and legislative competence concerning a European Business Code will only be determined in a long-term discussion involving representatives from various sectors across Europe. Lawmakers, business side, companies, politicians, of course, all the communities that represent large enterprises, SMEs, businessmen, so all kind of parts of the business, society, politics should be involved in this discussion to create a European Business Code. This is the task that we are facing now from my perspective. The European Commission has the European Business Code as an option in its white paper on the future of Europe already mentioned. It was from, as I remember right, 2017. So even the Commission has the European Business Code on the agenda. Maybe that would be too much to say that, but it has it in the view. And if I can quote this Commission's white paper, it's written there: a group of countries develops a common economic code in which company law, commercial law, and comparable regulations are standardized so that companies of any size can easily operate cross borders. That was the quote of the white paper of the European Commission from 2017. So already the European Commission has in their mind, in their view, this kind of codification, and we should take the chance, push it forward to lift this kind of field, to lift the whole EU single market on a new level, on new standards. The impulse for possible improvements and extensions to the acquis communautaire through the European Business Code have already been offered by a French initiative a few years ago, and now by a German initiative in the last year. For example, these proposals do not just refer to the European private company, but rather propose broadening company law in general. That's the benefit. For securities, it considers, for example, the introduction of a European mortgage and a truly European charge on property. Further, aspects posed for discussion include, for example, extending banking and insurance contract law, expanding European financial markets law to cover SMEs and retail investors, and integrating patent law and other relatively well-developed sectors into current intellectual property law. And I think the EUIPO, the European Institution for Intellectual Law, could play an important role in this issue, because what they do in Alicante is very, very forward of the whole issue in this case. The French initiative thus draws on many points that were already noted as improvements in the European business law and intends to include them in the new framework in preparation of a European Business Code. Although this compilation is commendable, it will first be the further work on this project that will lead to a clear identification of the outlines of the proposed code and its innovative features vis-à-vis the present acquis and traditional commercial codes. In particular, the changes arise from a modern European business code, from the digital revolution, which will require consideration far beyond the scope of above outlined. Coordinating the free flow of data with data protection law. Sometimes, let me just say this, it seems that we have in an act 5, 4, 6 regulations, which is for the business, and 20 or 40 regulations, which is for data protection. So we really should harmonize this and take a stronger view what business needs, what kind of needs are there, and how we can support business and enterprises. So coordinating the free flow of data with this data protection law, the rights to data, which cannot just be covered by traditional concepts of property law, liability in the Internet of Things, are all questions for modern business law, which also require an answer, perhaps, probably, or even primarily, at European level. Concerning all critics to the general data protection regulation, and I was one of the hardest critics, I sat on many panels in Brussels and discussed that, and then economy says we need a regulation, we need to have a clear basis what we talk about. So I think in general, this data protection regulation gave us now a common ground for discussion also in the European business law. So it's not just something that blocks us, it's also something that made the basis clear, and we can go now on and talk about the business side, what our enterprises needs, what the trade needs, and we could use this as a perfect ground to go further. Contracts for the supply of digital content, machine to machine, conclusion of contracts, or internet platforms also offer topics for future European legislation which do not concern just consumer law, but also B2B legal relationships. So again, let us not just concentrate on consumer law, which we did in the last years a lot of and many times, but now making a whole issue out of it, including all sides, of course, B2B, and especially take a view from the business side. The European Business Code, therefore, must not only be broader than a traditional commercial code and with a different structure, but it must also react to such new challenges that will be of crucial importance for the future internal market. So if you come from freedoms and you see how the change from freedom of goods go to services, then you can see what is changing there year by year, month by month, day by day. When I tell my students about video cassettes, I don't know if somebody of you still remember video cassettes or CDs or DVDs or Blu-ray. They say we talk about goods, but they say, what is this? We are streaming. We're streaming our music, we're streaming our licenses, we're streaming our movies. So we're going to services. The world is changing, so we also should change the law that's responsible for all these business activities. It's important to get in the new age. It is therefore fitting that soon coming year, and it's be very fast there, of the 70th anniversary of the Treaties of Rome, it's just a few years soon, then we'll have it, we'll involve a debate and start a debate on the changes for the future of European integration alongside whether and how European business law can contribute to stabilizing and strengthening the internal market for the next 70 years and beyond, I hope. At the 70th anniversary of the Treaties of Rome, we should have a following-up treaty after the Treaty of Lisbon, and we should have a European business code. Let's conclude with the idea of working on a European business code. Let us start the discussion now and go into details. We have some proposals, we have some drafts already that we saw, and we should all think about how can we not just go in single regulation, single directive, talk about single issues. Let's make a broader view. Let's create a European business code and include that with a lot of links to the new fundamental treaty that is a follow-up treaty to the Treaty of Lisbon. That was my inspiring remark, and hopefully I opened the idea what we could have in the next few years up to the 17th anniversary of the first treaties, especially the Rome treaties. Thanks for your attention.
Thank you, dear colleague, Professor Sensburg. In the morning, two of the speakers indicated all these projects and debates on creating European business law code or other forms. I think you succeeded in actually giving us a projection, or at least an idea of the near future on this. If you have any questions, okay, we have someone addressing.
Hello, Professor. It's an honor to be here present with you in the same exceptional academic conference, the first perspective on the European business law. Actually, I'm very happy to hear that a new business code will happen, but my question to you is concerning the situation with the horrible situation with the war in Ukraine. In your opinion, this situation will affect the elaboration of the business code? That means, do you think it will be accelerated, the process will be accelerated, or on the opposite will be delayed by this international situation?
It's a good question, and I should have a glass ball for that. But the issue is this. We can be shocked and we can say, we are stopping every activities and we're watching what the world is doing. We can stop and watch what China is doing. We can stop and watch how the USA will change their economic activities. We can see how other continents like Africa are getting stronger and stronger with a young society and the will to take part in all business activities as well, and economies that will grow because, of course, they see our possibilities and they want to participate in wealth and growth. So we can just be ones who watch, or we can the ones who create. The European market is the strongest one. I think our trade underneath the European Union is very strong and gives us a strong platform to elaborate it further. So I tried to speak out two benefits: to strengthen the internal market, which belongs to us, to the member states who take part in it. And we have a need to lift it in the new time because times are changing, the situations are changing, the business is changing. We should create the law that fits for this. And the second thing, which is also very important, is to make clear that Europe hasn't forgotten his strategy to be the strongest economic market in the world. We had this idea, we had this target, and after a while we didn't talk about it anymore, but the legal framework for this is necessary. So if the question is, do you think we'll manage it? I would answer, we have to manage it, and there's a good chance. The Commission has already posted in the white paper, you heard about in the morning and now, that there are drafts, that there are ideas, that there are proposals, and I talked about it again because I wanted to push it forward in a political process. If we all talk about it and say there's a need, I think there's a chance that we will see it. But if we gave up not talking about it and say it's good for a few books and a few articles, then we'll just find it in a few books and in a few articles and not in a code that we all can work.
Thank you very much.
Yes, is the answer.
Thank you. Thank you.
Thank you, Professor Sensburg, and I hope you're well, because I know you have COVID now, so...
I had it until today. First day today is when I was tested negative. Okay. So I'm very happy. I had no symptoms, but it was very boring sitting at home all the time. So I wished to be in Bucharest, but it was so short in planning. So first test today, negative.
Okay, we're waiting for you here because we are starting next week. We're here, face-to-face education. So clearly the international visiting professors can also attend our classes. and
We will
teach,
see
of
us.
course. Thank you. Thank you very much for attending
you.
today and the interesting presentation and opening the doors towards this possibility of having a stronger piece of legislation on what means European business today. Also related, I suppose that the next speaker's question was somehow to prepare her presentation, is visiting professor PhD Oana Gherghina, who is going to actually try, I think, to explain or to present some possible effects of the Ukraine war with Russia. So the title of the paper is EU Single Market Braces for Impact of Ukraine War with Russia. Mrs. Gherghina.
Thank you very much, Mr. Dean. As Mr. Dumitru already said, it's just I just try to put together some opinions and some ideas, taking into consideration the fact that this subject is very hot right now, and us as academics are not able right now to withdraw some definite I don't know how to say, some aspects that are with certainty, like 100% sure that these are the effects. What I studied regards the impact of the Ukraine and Russia war on the single market. The first thing is that I want to remember everyone that the EU single market actually is the greatest achievement that fueled economic growth and made the everyday life of the European businesses and consumers easier. And that happened by removing all the legal and technical and bureaucratic barriers in the EU that allowed the citizens to trade and do business freely. As we all know, according to Article 26 of the Treaty on the Functioning of the European Union, this article comprises an area that the EU is an area without internal frontiers, in which the free movement of goods and persons and services and capital is ensured. So actually, the broad provisions for the free movements in the primary legislation of the EU are the core of our internal market, which today is subject to, I think, the most important pressure that that someone could ever imagine. That means we didn't fully recover after the COVID-19 effects on the internal market, and now we are facing Russia war with Ukraine. Regarding the territory of the single market, we comprise 500 million inhabitants, as we know, which act freely without any internal borders or any regulatory obstacles. And Ukraine, the victim of the Russian invasion, have also been granted limited access to the single market in some selected sectors, the same like Turkey, for example, even though Ukraine is not in the European Union. The war actually affected Ukraine dramatically, and with this, I think also the internal market is affected. As regarding with the EU-Russia trade activities, probably you know that the trade between the European Union and the Russian Federation was governed by a partnership and cooperation agreement, which came into force in 1997 and was renewed annually until 2007. but talks on a new agreement were suspended by the European Council in March 2014 when Russia annexed Crimea. So, regarding the EU and Russia trade activities, Russia, I want to remind all of our participants that ranks as the third EU trading partner, representing 8.4% of the total trade of the EU, and the EU is Russia's biggest trading partner, with as much as 48% of the total Russian foreign trade. And also, EU is the most important foreign investor in Russia, with up to 75% of foreign direct investments coming from the EU. So, actually, the main EU exports to Russia refers to machinery, transport equipment like cars, for example, chemicals and electronic goods and agricultural products. But the Russian exports to the European Union are dominated by mineral fuels with a percentage of 74.9%. Which contribute to a substantial trade surplus for Russia. In 2014, the EU sanctions happened. That means the EU member states, to the voice of the European Council, considered the annexation of Crimea to be illegal, and the European Union has adopted sanctions for the first time against the Russian Federation due to its deliberate role in the stabilization of the Ukraine and the escalation of the conflict. The EU sanction in 2014 involved diplomatic measures and financial and economic sanctions, asset freezes and visa bans. So maybe some of us didn't remember, but actually the same sanctions and many more happened with today's war with Russia. And as we noticed, there was a coalition of states, EU states and other countries which are not part of the EU against Russia in this attempt to discourage Russia to use force and bombs just to reverse the Cold War. Because in my opinion, Russia lost the Cold War, and now with bombing Ukraine, they want to reverse this effect. There were countries like United States and Norway and Switzerland and other countries who promoted a coalition for sanctions against Russia. But as we all know right now, the Russian Federation also responded to the EU sanctions with some economic countermeasures. That means Vladimir Putin addicted prohibiting or limiting import for agricultural products from the EU, products like fruits and vegetables and dairy. And also the targeted countries for countermeasures were the EU member states, the United States, and Canada and Norway. But actually, I think the internal market of the EU was the most affected one, because 73% of the banned imports actually came from the EU. About the effect of the sanctions, official European sources note that in 2014, the EU goods exports to Russia fell, with estimates of the decrease varying from 12 to even 14%. However, I think it's difficult to disentangle the effects of these mutual sanctions from weakened Russia demand on the markets without sanctions. Actually, linking the diminish of the trade volumes losses directly to sanctions is not straightforward in my opinion, as they coincide with the two major shocks affecting the Russian economy, that is a steep drop in oil and raw material prices, and also a sharp decline in the ruble's value, which actually happened also as we speak today. As I mentioned before, the European Union economy was not impacted by the war in the best situation. That means the COVID-19 pandemic has caused a multidimensional crisis, as we all know, like the health crisis, the economic crisis, and the social crisis, which I think is the most important shock that ever happened to the world economy after World War II. Actually, the Monetary Fund estimates that the world economy had contracted by 3.5% in 2020, which I think it's worse than the stagnation after the global financial crisis in 2009. So actually, the war didn't come on smooth territory. It came on with the impact over an already fragile situation after COVID-19 pandemic. As we all know, the pandemic was a shock both to production and consumption, and actually what is important is that large-scale job retention schemes that happen at European level prevented a surge of unemployment, but also some sectors were strongly impacted, like, for example, air transport, tourism, restaurants, and entertainment, and so on. So, right now, I think Russia's invasion of Ukraine carries a huge risk for a world economy that's yet to fully recover from the pandemic shock. In my opinion, the conflict already looks like, I think, the most serious war in Europe since 1945. As probably you already know, immediately after the invasion on Ukraine, EU leaders agreed to impose new sanctions on Russia's financial, energy, and transport sector, and to introduce export control and blacklist some Russian oligarchs. But also, these situations means that the companies acting in the internal market, the companies of the member states that sell their products to Russia, will see some trade revenues falling. But also Russia, as a Europe's main energy supplier, could retaliate and curb some gas and coal and oil sale to the EU, even though this would be very costly for Moscow. Regarding to the EU's official position with this war in Ukraine, I think it's important to know what the chairman of the Eurozone finance ministers said, and he said that we know there will be economic costs. These costs will emerge over the coming weeks and months, but he also added that finance ministers will have to review the fiscal plans in coming weeks and to make sure that they can support the member states' economy if necessary in this new situation with the war in Ukraine. He also mentioned something very important, and this is the fact that this impact of the war will be different for different member states. So I think this information should not pass unnoticed, because I think it's important for countries like Eastern Europe to stay very close to the Western countries in order to have a more uniform strategy regarding the impact of the war on the internal market and the European economy. The head of the central bank, European Central Bank, Christine Lagarde, said that the main impact on the war in Ukraine was likely to come through higher energy prices and the uncertainty that will hit business confidence and consumption. I think that high energy prices and high commodities prices as a direct effect of the war will lead us to a very important question, and that is, are probably commodities a new weapon in 2022? Because as we already noticed, the war has many layers, and in one layer we see the bombing and we see the casualties, and this is horrifying. But actually on the long term, the increasing prices of energy and other commodities like raw materials or agricultural products, I think the effects are very, very long term, and I think that EU officials will have to develop some policies in order to mitigate these effects of the war, and also to address the possible manipulation of the gas market from Russia. So, in my conclusion, as I already said, I think the conclusion of my study is straightforward, and that is that in a war situation, in my opinion, commodities become a weapon probably as powerful as guns. The difference being in the way we see the effects. With guns, we see the disaster immediately, and lives are taken, and this is a very horrifying situation. But also the economic effects of war are killing us slowly and seamlessly. For example, the former Assistant US Secretary of State, Frank Fanon, also asked this question, and actually he just gave us an answer, and he said that commodities have been weaponized for a long, long time, and it's always a question of when does a state pull the trigger. Thank you very much for your attention. It was an honor and privilege to be present to the first edition of the International Conference Perspective of the European Business Law. And I hope this event will be recurring every year, and I will be present here every year. Thank you, Mr. Dean.
Thank you, Anna. It was, anyway, clearly maybe just an introduction for a future paper which, anyway, will be presented, take into consideration the reactions, because for the moment, as you can see, they are related mainly, at least from the legislative budgetary point of view, are concentrated on aiding the immigrants and not necessarily intervening in a way or another in the EU market. Still, you raised the question over there that the most sensitive is, of course, the energy market, because Russia is the main supplier of energy for the EU. And I would like to address the questions. Clearly, we are maybe far away from anyway a moment in which we can actually see what to do there. But with all the threatening process of stopping supplying gas, of increasing process and all that, As we know, we have shared competence between EU and the member states on energy, Article 194. So over there, we have, of course, the interconnection of all the energy platforms and all those policies at EU level. Still, the national states are the ones managing and legislating in these aspects of how they're using actually their own resources and our own tools over there. Do you see, of course, taking consideration what we have provided in the treaty, which is not easily to be changed, do you see in the near future a fundamental change on this, taking into consideration a threat? Anyway, in the end, we speak about something that we need in order to live. And if Romania is not there because it still has some independence from this point of view, there are countries which depend a lot on the energy coming from Russia. Do you see actually a fundamental change over there? Yes, you know, at EU level we have legislation in aspects of containing, of diminishing energy waste, or anyway using as much as we can the energy which comes from solar or wind or water, so not depending so much on gas or other resources. But next to all those which were already happening for environment protection, for a certain independence of EU on energy, so trying to find their own resources and funding and creating legislation in that area, on gas, on anyway interconnecting what exists now in Europe, do you see a fundamental change from the legislative point of view? Do you see a way to do it?
Yeah, thank you for the question. First of all, what I want to say and to address the honorable audience is that, in my opinion, I think this war had some impact regarding our conception and our approach to the European Union. And I think that we are more united than ever, and this conflict made this possible, unfortunately, with these casualties and all these other damaging effects. Regarding the energy market, I also think that Romania, even though we are not so dependent on the Russian gas, as you said, I think we'll have to have like a solidary position, and I don't think that I think that we have to align all the policies on the European Union level, and also the legislation should be according to these policies. I don't think that we have to have a divergent opinion just because we are not so dependent on the Russian gas. And what I think is most important to the Romanian legislator is to take this problem very seriously and to encourage alternative, through legislation, to encourage alternative sources of energy to be implemented. Because right now, as you probably know, there are many discussions, for example, with the green certificates and some suspension of the budget, and with this uncertainty and all this situation with the producers of alternative energy, I don't think that investments will be encouraged and projects will be developed. Yes, we don't have like a huge problem, for example, like Germany, who is dependent on the Russian gas on more than 0.5%. But we also have to take into consideration our situation and to encourage, because in my opinion, together with other joint plans of the European Union with new sources of energy, I think it's in our power also to encourage investments in alternative sources by easing the legislation and the authorization process. And this will also help get, like, for example, more predictable place for investors, because Romania has some potential regarding alternative sources of energy producing, and I think we need to address this by legislation.
Okay, thank you. Of course, at national level, we'll see how happens at your level. We pursue now and we switch from clearly strict in connection to the single market, but as an issue, we transfer from the single market to the capital markets, to the banking and financial area. And we have as keynote speakers next the president of the Greek Society of Banking and Financial Law, Dimitris Tsibanoulis. Next to Mr. President, we have two colleagues, attorneys at law, Mr. Konstantinotos Antonakis and Mr. Mikalis Pladanios. The paper is Capital Markets Union and Alternative Finance Providers. Is a European legal framework for loan originating funds needed? Mr. Dimitris, are you hearing us?
Yes, thank you very much for the invitation. Can you share probably the slides we have prepared, the PowerPoint? I don't know if it is possible.
Of course.
To give us the possibility to share also the screen in order to present, to share with you the PowerPoints. First of all, I would like to thank you for this impressive event. A lot of very important and interesting speeches and presenters. And thank you very much for organizing each year this tremendous event. Congratulations to the Romanian organizers, and thank you again for the invitation. We thought that it could be of interest to present a point of view regarding financing, and the title we choose with my colleagues here is a European legal framework for alternative finance providers such as loan originating funds needed in the European Union. In the aftermath of the international financial crisis and the sovereign debt crisis, we realized some insufficiencies in the traditional banking sector to finance the real economy and especially the small medium enterprises. Let me try now. I don't know why. Can you share that or how can we do that?
Yeah, we'll do it. We'll do it. One second.
So probably I can continue, and if we achieve to have the slides, it will be fine. So we are very well aware of the significant adverse impact of high levels of non-performing loans, non-performing exposures to European banks, especially of the periphery, Eurozone periphery, as to their ability to lend to the real economy, especially to SMEs. I don't see that. Okay. So, disburdening banks from their NPLs through the development of secondary markets for NPLs is one way for funds to flow to the real economy, so as to keep the economy going and enhance growth. The other way is lifting or easing regulatory impediments for non-credit institutions to finance enterprises. At European level, the exercise of lending activities is not reserved to regulated entities, by European law, I mean. However, in most member states, this is the case. And there is no common European legal framework for financial institutions, not being credit institutions or credit institutions subsidiaries, in order for them to be able to grant loans. Diverging measures are adopted at national level, which are likely to cause distortions of competition resulting from differences in investor protection measures especially. The real economy needs funds, and the traditional banking system is by itself, for many reasons, reluctant or inadequate in providing funds to small, medium enterprises. Could the capital market fill this gap? Raising funds in the capital markets through collective schemes, which could provide financing to the real economy in the way of lending, good. Yes, here we are, thank you, yeah. So, raising funds in the capital market through collective schemes, which could provide financing to the real economy in the way of lending by funds, and not only through investments, could be a crucial tool for growth in the European Union, achieving the channeling of European savings towards European investments. There is a need for long-term finance, putting the European economy on a path towards smart, sustainable, and inclusive growth in accordance with the 10-year Europe 2020 strategy, as well as enhancing employment and competitiveness with the goal of building tomorrow's economy in a way that is more resilient and less prone to systemic risks. Level playing field is, however, important in the European single market. No, you can be in the second, please. Yes, here. Yeah, level playing field is important in the European single market. So the question arises, which rules should be considered necessary in order to permit to collective schemes to grant loans in the market? Should these alternative funds be regulated? And if yes, to what extent? There is on the one hand the needs for prudential supervision and investor protection through raising funds, redemption restrictions in order to safeguard the long-term character of the funds, and the development of a sound secondary market for the unit's shares of these funds. On the other hand, there is the objective of achieving finance of lasting duration to various infrastructure projects, and unlisted companies and small medium enterprises in need of equity or loans for which there is no readily identifiable buyer. And not to forget, there are financial stability considerations which should not be underestimated. Balancing these legitimate, sometimes controversial interests is not easy. The Alternative Investment Fund Managers Directive 2011-61 is beneficial as regards the management requirements. It does not, however, until now provide a solution to the lending issue. An amendment, as we know, is being considered, and Mr. Adonakis will present this issue. It seems that the new European derivative law is needed, ensuring uniform and consistent rules within the Union for collective schemes, alternative funds, having access to capital markets and being able not only to invest in, but also to finance through lending such entities would undoubtedly boost European long-term investments and promote the financing of the Union's real economy, thus enhancing the implementation of the European Union's policies. I don't want to speak more. I would like to give the floor to my colleague Michalis, who will continue by presenting the credit funds legal framework or perspective in Europe. Michalis.
Thank you very much, Mr. Tsibanoulis. So we have established that there is a certain funding gap and that the traditional lenders have inadequate lending firepower. In this vein, private credit funds started to step in. According to IO's Condesma, there are two main different types of such credit funds. The so-called loan originating funds, which are funds that typically are allowed to grant loans, and the loan participating and restructuring funds, which are funds that typically acquire existing loans originated by other financial institutions. They both pose some certain financial stability considerations. It is true that as regards their credit granting activities, both traditional and alternative lenders pose similar risks to financial stability in terms of maturity and liquidity transformation and leverage, but they do not have the same systemic footprint. Since credit institutions accept deposits, have access to central bank liquidity, and are very important for the transmission of monetary policy to the real economy, are inherently exposed to liquidity shocks and bank runs, and very interconnected with other major financial institutions to the universal banking model. Of course, especially in Europe, they are also extremely difficult to substitute as regards their fully fledged lending activity. On the contrary, credit funds do not have access to deposits, central bank liquidity, or any other public backstop. Put it simply, they are only putting their typically sophisticated investors' money in risk. According to the ESRB, other key criteria to identify their systemic importance are substitutability and size, both not very worrisome at the moment, and of course their interconnectedness with other major financial institutions. Fortunately, as regards the latter, it is limited until now due to three main reasons. Credit funds grant loans typically to SMEs and not other financial institutions. Second, they employ limited or no leverage, and they are not in principle allowed to trade derivatives for investment purposes. And of course, they are typically close-ended, which protects them from liquidity shocks and possible investor runs. And this is exactly why they are very much important. And this is the added value they can have to the European economy, because since they are subject to lighter capital requirements and protected for liquidity shocks, they can continue lending against the cycle, thereby protecting the European economy from cliff edge procyclical effects. On the flip side, of course, they pose also financial stability issues and regulatory arbitrage opportunities. For example, think about banks that could establish such funds and employ them in order to transfer flow credit risk to the investors, triggering fears for a novel originate to distribute model. Moving on to the current framework for such funds at the EU level, as Mr. Tsibanoulis has already said, there is none coherent EU-wide harmonized framework. The Alternative Investment Managers Directive only regulates the manager and not the fund themselves, leaving the fund regulation to the national legislator. Combine that with the above-mentioned credit granting restrictions imposed by many member states, and you can see why there are not currently many credit funds across the EU. Unfortunately, other sectoral regulations like the venture capital regulation or the long-term investment fund regulation have proven themselves inadequate to fully unlock the potential of private credit financing into SMEs. So we do not have a coherent EU-wide framework for those funds, and we are obliged to examine those funds through the lens of national law, and in an attempt to pick up the pieces of a divergent and fragmented regulatory universe and scratch up their legal toolkit. Establishing and examining the things across Europe, we can see that there is a consistent degree of harmonization when it comes to preventing such funds to grant loans to consumers, and of course, imposing certain requirements, like Mr. Tzibanouli said, in order to limit their leverage and protect investors, especially retail investors. And since we do not have a coherent EU-wide framework until now, I think it is time for me to give the floor to Mr. Andonakis, who is going to present us the so-awaited IFMD2 proposal rules on organic funds. Thank you very much.
Thank you, Michael, and thank you to the organizers of the seminar and to Dr. Tsibanoulis, who spoke before me, and thanks for that, I noticed. In this third part of our common presentation, we intend to go through expected changes in the field of loan originating funds, European regulatory framework. And to start with the background, first, I should reiterate and repeat what Michael just said before, is that the European legislation in force regulates the manager of the alternative investment funds, not the funds per se, which is a first issue that we have to deal with. The background is that a deep review of the Alternative Investment Fund Managers Directive, the IFMD, has been ongoing in the European market for a number of years. And after a lot of discussions, in October 2020, the European Commission has launched a relevant consultation based on a report that was coming from the European Commission, and that consultation was sent to the European Parliament and to the European Council for discussion. The conclusion of this process was that, in 2 words, although the existing Alternative Investment Fund Managers Directive provides a high level, a satisfactory level of protection to investors, there were a number of areas that have been identified as weak areas needing improvement. Quite recently, there was an additional intervention coming from the European Securities and Markets Authority, ESMA, which in an official letter addressed to the European Commission, recommended some key priority areas for consideration, including delegation and substance requirements for the managers of the alternative investment funds. The timing concerning the completion of the review of IFMD is the following, is that by the end of November of last year, 2021, the European Commission published the long-awaited draft proposals on the IFMD amendments. Such proposals are expected to be reviewed by the European Parliament and the Council, and the final text, which will be adopted, when adopted, is going to be published as usually in the official journal of the EU. And after that, the new directive is expected to enter into force 20 days after publication, while in the level of member states, the member states are expected to be given 2 years, 24 months, from the publication of the FMD2 up to the alignment of their national legislation to its provisions. The IFMD2, based on the draft proposals we have seen until now, contains some important chapters, provisions concerning the loan originating funds. I think they could be summarized in 6 or 7 main axes. The first one is that fund managers who manage alternative investment funds, which are loan originating funds, are going to be expected to implement effective policies and procedures for 3 topics: the granting of credit, the assessment of the credit risk of the borrower, and the administration and monitoring of the fund's entire credit portfolio. Since this activity is going to, one way or another, be directly or indirectly supervised activity by the national competent authorities. The second axe which is going to be activated is the update mechanism, which is expected to oblige the managers to ensure that the relevant policies and processes, which we mentioned before, will be reviewed very regularly, and this means at least annually, in order to be adapted and to reflect properly risk management issues the managers are going to face. A third topic introduced by IFMD2 is investment restrictions concerning loan originating funds. So the managers must ensure that any loan originated to one single borrower entity shall in no case exceed 20% of the fund's capital, where the borrower, in case the borrower is a financial institution, for instance, an insurance or insurance company, a credit institution, an investment firm regulated by MiFID, or a financial conglomerate, or a UCIT, or even a management company of another EIA. A fourth topic is loan granting interdictions, which expect to cover a full interdiction for the fund manager of a loan originating fund to grant loans to himself as a manager, or to any delegated person of the manager, its staff, or the depository of the fund. The fifth axis is going to be the risk retention mechanism, which is expected to impose to the managers of loan originating funds the obligation to ensure at all times that the fund, it manages and retains 5% of the notional value of the loans it has originated and subsequently sold on the secondary market. Then there's going to be some enforcement of the investor protection. It's expected the investor protection aspects to be further strengthened, in the sense that the fund manager shall adopt close-ended structures where they engage in loan origination to a very significant extent, meaning investing more than 60% of their net asset value in lending activity. And the last one, I would say, is that IFMD is going to bring some legal clarity, since in its Annex 1, it is expected to be clearly confirmed that loan origination activities are activities which can be performed by fund managers when managing alternative investment funds. I would finish this part of the presentation saying that a number of areas still remain uncertain concerning IFMD2. Issues such as the duration of the loans, the information disclosure to investors and the national competent authorities, and the level of details it will comprise, as also the eventual interaction between this European regulatory text and the particularly fragmented national regulations concerning banking monopoly. All these issues remain to be answered once the directive will see the day. Thank you very much.
Thank you so much for the presentation. Any questions from the people online, maybe?
If no one online asks, I have anyway taken into consideration that the paper was on loan, and in Romania nowadays we have a debate on a certain type of companies, which are the financial non-banking companies. I was wondering how is it in Greece or anyway in other legal systems, because in Romania we have new piece of legislation, secondary, but we still have in different areas like tenders and others, where they're limited somehow to offer loans to companies. Just because they're not banking companies, and I was wondering, how do you see this anyway? This limitation on credit on loaning activity of these certain types of companies which exist, they are regulated.
Thank you. Thank you for the question. It is a very interesting one. Apart from the rules emanating from CRG, allowing for subsidiaries of credit institutions to grant loans, in Greece we have several types of financial institutions which are regulated, such as leasing companies, factoring companies, companies which are allowed to grant credits to natural persons, as well as to microfinance. So there is no, the market is fragmented from this point of view. We don't have any single financial lending entity which could provide simultaneously, for example, factoring, leasing, credit to consumers, etc., without, of course, accepting funds, because that would render this institution to a credit institution. And for this one, we have a different, at the European level, of course, type of regulation. So this is a very important point in the Greek market. You know that unfortunately Greek banks are in a very bad situation regarding NPLs, and real economy needs financing, not only through investments, for which we have, if you want, legal schemes allowing investments, but also through loans. And here the capital markets in Greece is not very developed due to these legislative impediments, not allowing not regulated institutions to grant loans on the one hand, and on the other hand, due to the fact that also the financial institutions which are allowed to grant specific types of financing are fragmented. We have not, for example, a common scheme financial institution for leasing, factoring, granting loans to consumers, or microfinance. We have several times which have an exclusive by law scope and target. That means they are not allowed to simultaneously grant other types of loans.
And so I can say that the reaction of the Romanian government in restraining, because in the last years it was a huge development of this type of companies, again, non-banking financial companies, but they are supervised by the National Bank of Romania. The only distinction is that they don't have the same criteria and the same authorization as a bank. But this reaction may come actually natural in the idea that it's kind of dangerous to allow them to offer loans or to guarantee, for instance, in anyway deliveries, works and others. So yeah, as you mentioned, in Greece we have just like in Romania, we have other fields like leasing and others, but you don't have this area which is corporate, and might actually be a reaction which is in accordance with the European legislation, and as you mentioned, might actually be in other countries, meaning limiting them to strict objectives. Thank you very much. It was an interesting paper. I thank all three speakers. We hope in the near future to have you again to some of our events, and why not maybe in a face-to-face event, maybe here as visiting. Thank you very much.
Very much, Steve.
Now, continuing in relation to the single market, we touch also problems of competition. And Mr. Ovidiu Maican, lecturer, decided to analyze the legal regime of competition in Slovenia, a member state of the European Union. After that, we'll have a special presentation coming from Walter Skluver and a break. But first, let's hear Professor Maican on competition in Slovenia.
Hello, do you hear me? Okay. Unfortunately, my camera doesn't work, so you are going now to listen to me. I choose such a topic because Slovenia was, like Romania, a former communist country. And like Romania, after joining the European Union, they, let's say, adapted or they copied a very big amount of European legislation. From constitutional point of view, we have in the Slovenian constitution the base of competition policy are Articles 33 and 74. Their first legislation in this field of competition, it's from 1994. And as a result of this law, they were created the main institution in this field. And we are speaking here about Slovenian Competition Agency, the main competition authority in Slovenia, which is a part of Ministry of Economy, and State Aid Monitor, a branch of Ministry of Finance. The competition authority, the main authority, has as targets of its activity the prohibition and prosecution of restrictive commercial enterprise practices, the prohibition and prosecution of abuse of dominant position, and merger control. The members of this competition authority are appointed for a period of 5 years. The Slovenian competition law was adopting a lot of articles of European legislation, and we are speaking here mainly about the articles 101 and 102 from TFU, Treaty of Functioning of European Union. The main article of Slovenian competition law is Article 9, modeled on Article 102. This article prohibits the abuse of a dominant position by one or more undertakings or enterprises in the territory of Republic of Slovenia, or in a big part of it. As you see, is let's say an adaptation of European text. The CPA, I mean the Competition Protection Authority, like other national competition authorities, is empowered not only to analyze and to investigate the infringement of competition rules, but also to impose fines. So here we have two sorts of procedures. One is administrative, and the other is about imposing fines. In the first phase of investigation, the CPA establishes the infringement. This decision of beginning of the procedure is published in the on electronic base, and after the investigation, this decision of CPA can be attacked, of course, with, let's say, appeals, because as Professor Brândușel Ștefănescu said in the morning, in the Anglo-Saxon, let's say, procedure, any way to attack judicial decision is called an appeal. Here in Slovenia, you can make the first appeal, let's say, to the administrative court, and after that to the Supreme Court of Slovenia. After the beginning of the investigation, the office or the authority can address a request for information to each of the undertakings investigated. The summary of the order of beginning the investigation is posted, of course, on the office internet web, and it contains the following elements: the indication of the parties, a declaration of grounds for the initiation of a procedure, the provisions of Competition Act, so the judicial grounds, and an invitation for the persons involved to send to the office any information and statistics. Usually, the office is using not only a so-called written investigation, but also an oral hearing. The Supreme Court, because we spoke about the last judicial court involving competition problems, is deciding in a panel of 3 judges. But, for example, to speak about the activity of the Protection Authority, there are some fields excluded from the competition law. We are speaking here about public acquisitions, railway, banking, and insurance. But we don't have only the Competition Act. We have more decrees set up in the 90s, completing this law. But in the last years, is necessary to let's say, to enlarge the degree of transparency in the decision-making of the authority, and to set up more ties with other public authorities and representative of Chamber of Commerce. But the main request from public opinion to the legislation is to introduce a single procedure. So to merge in one procedure the two previous ones, I mean the procedure for infringement and the second procedure for fines. Okay, I was very brief. If you have some questions. I was brief because now at 4 o'clock I have to commence my class of distance learning.
Okay, thank you. Yeah, clear competition, especially nowadays, it's an important area, and with continuous development at your level, you know, only on mergers control how the regulations actually changed from time to time. And on this, I wanted to ask on, anyway, at least how, taking into consideration the experience with the Romanian Competition Council, the Romanian authority, that in the last years, they reacted in different fields. How actually reacted, or how is the action of the national Slovenian competition authority? The idea is, well, which are the cases, most of the cases, towards what it leans to, which is the most dangerous anyway from the economic point of view as area over there. In Romania, we had some issues with advertisement at a certain moment, with the pharma industry and others, transportation it was, so tourism, so we had different areas. And over there, both the agreements and the abuse were interpreted in certain ways by our national authority. How is with the Slovenian authority there?
I didn't analyze too much the certain cases, but in the last years, the biggest problems they had in Slovenia with the pharma business. The biggest number of cases, it is in the field of pharma cases. But as I said, another bad aspect is that some sectors are excluded from competition legislation, such as telecommunication, railways, electricity, oil, and gas.
I understand. Okay, thank you very much, Mr. Maican. And now, before the break, I would like to invite a representative of our partner, Wolters Kluwer, Romania, Mr. Gabriel Ungureanu, and he will actually lean towards technology, something that nowadays it's debated a lot. The title of the paper to be presented today is Artificial Intelligence, the New Way of Legal Research. It's a debate that we have. It's gonna touch artificial intelligence justice or anyway, other legal environments. Clearly, business is already touched. Clearly, many areas from medicine, automotive industry, and others are already there. But how much is actually touched this field in which we actually engage ourselves every day? Maybe we'll find out from our partner and anyway the executive director of Wolters Kluwer Romania, Mr. Gabriel Ungureanu.
Hello, my name is Gabriel Ungureanu. I'm executive director of Wolters Kluwer Romania. I'm more than honored to be here today next to distinguished professors, students, and professionals. Thank you very much for your invitation. Today, I will address a hot subjects and also a hot legal tech topic, the significant improvements brought by AI technologies in the field of professional legal research softwares. Let me share my screen, please, and please let me know if you could see the screen. Okay, coming back. So next, I will touch the following topics. First of all, very briefly, who is Wolters Kluwer. Then we look at the foundation of a legal professional job, lawyer, legal counselor, and at the areas where the new technologies can be a game changer, can bring a relevant contribution or a relevant competitive advantage to those who use them. Later, we identify which are the legal business areas which could be impacted by AI. Finally, exemplifying how artificial intelligence makes effective search of the relevant case law from big data volumes. So, very brief, who's Wolters Kluwer? It's a global company, one of the leading providers of specialized information and software solutions dedicated to high-end professionals from finance, banking, health, accounting, risk, compliance, and of course, legal professionals. In Romania, Wolters Kluwer mainly supports legal professionals. The company provides services from legal and paralegal fields, legal advisors, lawyers, magistrates, notaries, or executors, but also to all those who in their daily activities has to be updated with legislative and regulations changes, such as managers, tax specialists, finance, accounting professionals, or HR experts. But let's step back and ask, what is actually the activity of a legal professional? What does a lawyer or a legal counselor has to do to be competitive? To identify the answer, I refer to the value chain concept stated by Michael Porter since 1985. This flow includes all strategic and operational elements subscribed to the organizational goals. In our case, the goal is to provide valuable legal services to internal clients, if we are talking about the legal department, or external clients, if we refer to a law firm. However, Porter also refers to the competitive scope to deliver a value of services higher than costs, which is quite normal. The revenue stream has to be more consistent than associated costs. But to strengthen our relationship with beneficiaries, with our internal or external clients, the services must be at the best possible level. So the perception of beneficiary regarding the amount paid to be positive, favorable for us. I mean, I paid less than I actually received. So we are facing two divergent trends. First, to deliver more services. Second, with less costs. To get the answer, according to Porter, we understand that in relation with the beneficiaries, the differences in perception are created by primary activities. How quickly we respond, how well we are documented, what is my performance in court, what concrete results I deliver, what tariffs I have. The primary activities consolidate these advantages. Therefore, the quality and consistency of customer interactions matter. I mean the primary activities. The support activities, those that actually support the smooth running of the main activities, must be performed efficiently, mainly automatically, with minimal costs. This balance allows the organization, even if it's a legal department or a law firm, to place itself in a competitive posture. Thus, the legal professionals must spend as much time as possible in the primary activities area, the support activities being more than recommended to be automated or delegated. Some of the main activities are exemplified in the upper quadrant, the support ones being shown in the lower quadrant. Redrawing the value chain, we get the following graph. What makes the differences are? The prerequisites, I mean the information I rely when I have to formulate a professional opinion. It matters how fast and smooth I can identify strictly the information I needed. Of course, the quality of the provided services, the deliverables, are more than important, and the communication and post-communication and post-service communication are also critical. But the area that can generate the greatest impact is the legal research. This area can involve up to 50% of a legal professional's time resources. And until recently, the problem of a professional consisted in finding and collecting the necessary information to run the activity, and I'm not referring here strictly to the legal field. Now, the problem is not collecting, it's the capacity to identify the relevant information from a huge amount of data and information available for all. Because professionals must identify from a very large volume of data the information necessary for the studied case, legal research becomes nowadays a challenge both from quantitative and qualitative perspectives. And here, the new technologies, artificial intelligence with machine learning, natural language processing, and other technologies could bring a relevant support. So, to meet the Romanian professionals' needs, we carried out a product research and development project. At the end of the process, we launched a product that came to support all legal research activities. Romania was one of the first world's 5 countries that had a legal tech commercial product based on artificial intelligence. What we relied on to solve this problem of professionals? Using artificial intelligence, machine learning, and natural language processing algorithms, we analyzed, categorized, and interpreted over 14, now are actually 15 million court decisions. Every day, between 3,000 and 5,000 of new cases enter in this basket. All content is integrated, correlated, and managed by the legal research software professional platform named syntax.ro. So we have a legal tech tool empowered by AI that can identify from 15 million of case laws only the specific cases which have strings of keywords, refining the selection according to a field of practice, a court, or even to a panel of judges. For example, if we want to identify cases that require the claimant to pay moral, I mean non-pecuniary or non-material damage for a defamatory article published in a newspaper here, the platform can easily identify those decisions which the court has decided exactly this. Then the results can be selected down to the level of the court panel. Those for all identified court decision, their summary is listed so the professional can easily find those cases that best describe the research topic. Then the following are listed: the parties involved in the category, I mean public, institution, economic entities, private person, etc. The judge's panel resolution, admitted, rejected, or partially admitted. The procedural stage and the case evolution through different courts and levels. With all issued decisions in a row, like here. Of course, according to all this metadata, various filters can be applied. Thus, any legal professional, after typing 5-6 words, of course, relevant and descriptive ones, can easily identify in less than 5 minutes the right court decisions. In addition, the legal research software correlates up to the level of a certain article of law everything that is relevant for a deep dive legal research. Related legislation, other similar court cases, a comprehensive library with national and international content from different prestigious legal publishing houses, content of a large collection of scientific journals, question and answer models, and many other secondary content categories. So we can identify any topic which are interested in. From legal research software perspective, we have to do 4 simple steps. Identify legislation, select a category, a court or an appeal court, apply supplementary filters to refine the results, push the AI button, the analytics button, everything is done. What I listed in the previous slides is just an example. Any professional can search for almost anything relevant to the research topic. For example, you can research by the expression to pay. The application identifies the expression and marks it as such. Then, I don't know why has to pay some amount. So for lack of use of what of the land being listed in a dynamic and predictive mode. Various expressions that help me to find the needle in the hay wagon. Likewise, we can identify expressions such as to issue, what property, certificate, the title, to cancel, to confiscations, what I have to confiscate the bitcoins, etc. Everything I can search in this platform easily in 5 minutes and to find any relevant court decision. So here is how, for the most time consuming stage of the legal value chain, AI is able to, for legal research that have consumed many hours till now, it's able to engage an effort that it's quantified in minutes. Please see the percentages, see how the percentages have changed, how much time the professional can now allocate to interact with his clients. It's a relevant paradigm shift. Please see how the percentages migrated from left, office time, to right, let's say customer time. The professional invests time in areas that bring value, improve the client perception of the value of the services provided. In conclusion, allow us to issue, let's say, higher invoices. This is the new technology's impact, and from my point of view, we need to look at the technologies as being a professional ally. It will support us in daily life, it saves us time, and so we become more competitive. We don't have to fear about it. AI will not replace us. There are many whole sets of studies that certify that the AI will not replace the legal professionals, but will support the legal professional to perform faster, better, more efficiently, and more effective. And I'd like to end my presentation with Jeroen Zivers' quote, one of the members of the board of the European Legal Tech Association. Technology will not replace lawyers, but lawyers who use technology will replace those who don't use it. Thank you all for your attention.
Thank you also. Now, you presented the presence, the use of artificial intelligence in collecting data, in of course assessing that data, in offering certain results, so helping in different professions like lawyers and judges and others to do the everyday job without losing time or any other resources. And this is one side of the artificial intelligence, which is actually collecting that data and analyzing and offering those results. What about the artificial intelligence which actually learns itself? And I'll give up anyway a view now. let's go to lawyers, because I avoid going to courts. You know very well that there are some projects at international level of replacing courts with robots, with artificial intelligence. But maybe anyway, that's risky. But at least for lawyers, is there any possibility to see in the near future this artificial intelligence not only collecting data in time, but actually supplying to the lawyer for a final view of an action in court, filing a certain a certain argumentation after collecting the data, and learning itself in the idea that knows how the lawyer presented himself herself in courts and which is the view on certain issues and all that. So replacing in a way being the assistant of the lawyer is far away, or actually may happen in the near future.
Thank you for your question. Very interesting. It's a very interesting one and very, let's say, deep one. First of all, I would like just to point something regarding the robots, let's say, which are going to replace the judges in some courts. Of course, there are some robots implemented in, let's say, in Estonia, as some robots implemented also in China, I think. But those robots just prepare, let's say, and issue a preliminary opinion regarding the cases which are in the courts. But those robots are they are issuing an opinion, they are supervised by a judge, by a human being, let's say. And those robots address only very simple cases, not complex one, not cases which request, let's say, deep dive professional expertise. So I think here we are far away from having artificial intelligence judge. Regarding the second part of your question about AI being an assistant for a lawyer, we are very close here because, for example, I presented previously how the artificial intelligence can easily identify cases very similar with what I'm going to sustain in the court, to what I'm going to do there. For example, in this motivation of the court, in the motivation of the court, of the judges, I can easily find arguments about my new cases. Also, we can refine the search up to the level of a court or of a panel judge. So we can see how the judge look at the similar cases before, and as a lawyer, I can easily adapt my defense according to previous cases in the court. We can do that right now, and of course, the mechanism, the artificial mechanism, can be improved year over year.
Yeah, I understand that, and clearly this side, because that's why I said that we speak about two types. Now, this was also a result of a research project that we had regarding the liability for artificial intelligence decisions there. And we have to make the distinction between this type of artificial intelligence which works with data, collecting data, analyzing, and even offering certain results, like you pointed out.
Yeah.
And the other type, which for the moment you consider that is far away, anyway, in that robots, in the idea that it learns itself. So the data over there is not only the case law, former judgments, or different books, or different opinions, or I don't know, legislative acts. No, next to all that, in comparing and having certain algorithms, where I'm talking anyway, where I'm pointing out, and this clearly exists, and in different industries, like in medicine, when they offer a certain diagnostic, they share information, but also they have to identify, have certain algorithms on the feature of that intervention, or how much is it, how it costs, and other things, other elements, other indicators. I'm talking about that robot, in the end, yeah, we call it robot, taking decisions how to go to court, yeah, to reject or not the case, and also data like, for instance, if it's a certain type of lawyer, yeah, with certain views. So that's why I was asking. Clearly, we don't see it now possible because it's far away, we consider, but in other industries, it exists. Now, in cars, it's not only about the data collected from the street or GPS and others anyway, it's also about other things over there. So still working, but existing. So that was anyway, it's a debate. I know it's a debate. Yeah. We had a debate on liability. What happens with one type of intelligence, artificial intelligence? We have a producer, we have a supplier, we have a user, where you control the data. And what happens when none of them, from producer to user, you don't control the data because the robot is learning itself?
Okay, I really understand your question. More or less, the answer is yes. But what we have to take into consideration, the machine learning algorithms are mainly mathematics. The artificial intelligence learn what we allowed the artificial intelligence to learn. I mean, we can control this process. Then, the predictive analytics, it works. Also, our solution has predictive analytics modules. I mean, if I'm going in the cart with a case, I can share my screen and you can see. According to the type of case, according to the court, according to the judge panels, I can see if I can win this case or not. And as a legal professional, I could advise my clients if it's worth to go forward in the court with the case or not. According to how I'm searching, how I'm what metadata and what let's say keywords I'm using when I'm doing this search, I could know if it's recommended to use some arguments or not. But you know, artificial intelligence is mathematics. It's not nothing else, and the human touch, the professional input, it's relevant. If you have time, I could show you right now for a case how can I use the predictive analytics, what the cases are, what my odds to win are. It's simple. It takes 5 minutes, no more. For a case, I really don't know what case, you can choose it. But the artificial intelligence can go there, but especially in legal fields, the professional input, the science of the law, let's say, it's relevant, will be relevant, and the human cannot be replaced by artificial intelligence, and the human final touch, the final judge cannot be replaced by artificial intelligence. The artificial intelligence, it's a, let's say, an assistant, as you said before. It's a very smart assistant, able to process in 5 minutes millions of documents, to bring you on the plate the relevant information you need for, but will not replace the legal professional.
So good news for the lawyers and judges. They won't be replaced, at least not soon.
Yeah, I really want to point this aspect because there are a lot of debates regarding this topic.
Yeah, we understand. Thank you. It was an interesting presentation. Now, just to correlate with the title of the conference, we have a proposal of a regulation in this area of artificial intelligence, and I advise all professionals to start investigating because, yes, good news, we won't be replaced very soon, but clearly our area, the professional activities is changing and artificial intelligence is present. Hopefully will help us to develop in the best way. Thank you very much.
Thank you.
Now it's time for a break. As I check the schedule over here, we should come back at 16:30, maybe 35. So 10 minutes break, and after that we'll reconvene for the last part of the conference. Thank you.